Welcome back to our second panel discussion of today. Many business issues intersect the legal and HR functions of a company. In this section, we have invited Ms. Fiona LOUGHREY, partners Simmons & Simmons, and Ms. Michelle TENNANT, Director and Head of Employment Legal, Asia Pacific, Deutsche Bank AG, Hong Kong branch, to share their experience on tackling common legal employment problems and tips for in-house lawyers on establishing an effective working relationships with the HR team. Joining them is the moderator of this panel discussion, Ms. Joyce Cheng, Senior Corporate Lawyer, Australia and New Zealand Banking Group Limited, and member of the In-House Lawyers Committee. I shall now hand over to Joyce. Joyce, please.
Thank you. Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. Welcome back from the nice little break. I hope you've got a chance to catch up with friends, to catch up with your emails, or perhaps a cup of coffee. And welcome back for those participating online. It flows very naturally from the first session. We talked about privacy in direct marketing and also in sales. But actually, in the HR world, personal data is also very important. But of course, this is not just about personal data. Us as in-house lawyers is the corporate connector. The relationship between legal and HR is crucial, is critical nowadays in the whole cycle, say, from the development for the company about like tenant recruitment, talent retention, incident handling, policy making, process management, etc., etc. So the relationship between HR and legal and whether there is any effective alignment is become more and more important. And sometimes there are like funny moments between HR and legal, and this is what we're going to talk about more in this session. And I'm very honored to be the moderator of this session. This session is going to be a free-flow, conversational panel discussion amongst the speakers. And we hope there will be about like 5 to 10 minutes towards the end for the question and answer session. So let me introduce our esteemed speakers. Ms. Fiona LOUGHREY, partner at Simmons & Simmons. I think no much introduction needed. She's the leading employment law lawyer in Hong Kong. And also Ms. Michelle TENNANT, Head of Employment Legal Asia Pacific of Deutsche Bank. We are very happy to have a representative from the private practice and also a representative from the in-house employment legal department to talk to us on this topic from the different perspectives. So Fiona and Michelle, as I mentioned in my introduction, I think the strategic collaboration between legal and HR is very important to minimize or reduce the risk of employee claims and investigation, but it's also very important for the corporate to build up their positive reputation and actually culture for the company as an employer. But then it's easy to say, when it comes into practice, there are like some frustrating moments. For example, like during COVID, the employment-related legal requirements keep changing constantly. For example, from the HR perspective, everything is so sensitive and confidential. For example, like whistleblowers, complaints, investigations, that kind of matters, handling of that kind of matters could be quite tricky as well. And also in terms of like policy making, etc., etc. So perhaps the first question for Michelle, as an in-house employment lawyer, what kind of things have you seen or experienced that create risk and result in issues falling between cracks?
Thanks, Joyce. So I think the biggest issue that I have seen that leads to further issues happening and things falling between the cracks really is a lack of communication and cooperation. I found that good communication really is the easiest way to make sure the organization is covered from an employment legal perspective. In my experience, it's very useful if at the outset you can delineate between what HR does and what legal does. The worst situation you can be in is where something comes in and HR thinks legal is dealing with it and legal thinks HR is dealing with it. And then you either miss a deadline or it doesn't get dealt with, and then that leads to further escalations. That also ensures that absolutely everything is covered. You have, two buckets, one for HR, one for legal. There should also be a protocol on how HR and legal can work together. So for example, what gets escalated to legal, what can HR sign off on? Does everything that HR produces has to go through legal? For example, I know of one situation where HR asked legal to review a letter that they wrote. That in itself is fine. However, the letter was actually an administrative letter that was being sent to a private members club for which the organization had corporate membership as a benefit for employees. And the letter was about the return of a car park label. Like, I don't think that is something legal necessarily needs to sign off on, and it's not a very good use of everybody's time and resources. So having that clear delineation, in that particular case, maybe the head of HR could have signed off on it, or an internal HR process as opposed to involving legal. Generally, HR teams will deal with the more employee-facing side of things, policies, documents, training in some cases. Depending on how the organization is set up, HR may also play a role in relationships between managers and employees, general counseling kind of. In some organizations, there may be an ER, employee relations function, that may carry that out. HR may also have an investigative function, so they may look into complaints around discrimination, sexual harassment, that kind of thing. But again, in some cases, that may be done by ER, the organization is set up. On the flip side, in-house counsel, employment counsel generally take on more of a counselor role. So things like keeping up to date on the law. You mentioned changes around COVID. In the last few years, we've had changes to discrimination laws, the Employment Act, MPF, all of that. So staying on top of that, making sure everyone's aware, running appropriate training, mitigating and identifying risks. Legal should also be mandated to ensure the organization takes appropriate steps to protect itself. So whether that be, as I mentioned, training, for example, in the sexual harassment or discrimination situation, but also making sure documentation, templates, et cetera, are all up to date. Only, I think, by working closely together, really can the organization be protected from an employment legal perspective.
Maybe I will have a follow-up question for Michelle first. How about when legal is being brought into a matter at a very late stage? Have you ever seen that kind of situation before?
Yes, and it's very messy.
Anything that you think can help to avoid that?
Really getting legal involved at an early stage can help shape how the matter goes. There have been some situations where HR have made a decision, or the business has made a decision, HR have executed that decision, and it's not been done in a way that recognizes the risks or takes them into account. And so by the time it lands on my desk, it's this big steaming hot pile of poo, and it's really difficult to unravel in some cases. So getting legal involved early, and we can then make a call as to whether external counsel, so for example, Fiona, is needed, because sometimes we need either an extra pair of hands or additional guidance on how to steer us, set a strategy. And doing that at the outset, I think Fiona will agree, is much easier than when everything has already been done and it's a mess.
Yeah, thank you, Michelle. I think the theme here is that legal shouldn't be too reactive. Sometimes we need to have constant communication with the HR department. So maybe I will turn to Fiona Lan. As a private practice lawyer, I think you're getting lots of calls from your clients on a day-to-day basis. So number one, what are the frequently asked questions that you've got? And what's your observation on how the relationship between HR and legal could actually affect the outcome?
Thank you, Joyce. Thank you, Michelle. Goes without saying, I think, but I agree with everything that Michelle has said. Getting legal involved early, and this is to your second point, Joyce, so just comment on that at the outset. Getting legal involved early doesn't mean that HR or ER are handing the matter over to legal. Sometimes just a 5-minute input or skim from Michelle or from external lawyers will be enough to flag the issue and to, got very moody microphones today, just knowing that is happening and deciding to what extent you or somebody in your team want to be involved will be enough. But if it's left until the last minute, that can really throw up some problems. Joyce, you asked about spending time on the phone and frequently asked questions. Yes. The thing about employment law is that it's often urgent. Things, hiring, firing, those sort of things can't really, wait until next week. So yes, I spend a lot of time on the phone, and the lawyers in the group spend a lot of time on the phone. A list of frequently asked questions would be really long, but just to take some sort of typical examples, the sorts of things that Michelle and I have to deal with. I'll start with hiring and firing. Sounds kind of basic, but notice periods, you specifically mentioned notice periods to me, and I agree. You'd be surprised how it's possible to get the assessment of notice periods or the calculation of the payment in lieu of notice wrong. For example, you might be laying off a team, and some of the team are in Singapore and some of them are in Hong Kong. Hong Kong changed its law in 2007, I think, to set out a new formula, different formula for calculating payment in lieu of notice based on a historical backward-looking calculation. But previously, the formula was what the person would have earned. And there's a piece of litigation over that. And as a result, the formula was changed. But in Singapore, and in Singapore nowadays, the Employment Act applies to all employees. In Singapore, they still have the old phraseology, would have earned. So I've seen people get slipping up there where the different formulas, which are legally required in the respective jurisdictions, give rise to different results and different treatment of team members. So another thing that I think you were interested in, Michelle, was garden leave and whether there's a right to put people on garden leave. I think whenever you're in a situation where somebody's going on garden leave, either because they're resigning or they've been let go, but for various reasons you don't want to release them to the market just yet, you do need to consult legal, because it cannot be assumed that there is a right to force somebody to go on garden leave. And I remember a client, a non-Hong Kong based client, some years back, many years back, being quite surprised and quite upset when I told them that garden leave, they'd been relying on the fact that they could put somebody on garden leave, and they hadn't wanted to have restrictive covenants when they were setting up their contracts long before lawyers were involved. So they had these contracts without restrictive covenants, but a long notice period in Hong Kong. The employee and the new hire, the new company hiring them, the competitor typically, can buy out, and there's absolutely nothing that the current employer can do about that. So that would be an example of the example of contracts being put in place without understanding all of the local implications. And I already gave you an example of how the considerations can differ place to place in the Singapore and Hong Kong notice provision. Okay, and I briefly mentioned restrictive covenants. I'm pretty sure that ER and HR would usually involve legal in drafting of those, but what about enforcement? Is it a good practice to pay somebody for restrictive covenants? The legal answer to that varies jurisdiction to jurisdiction. There's been a case on that in Hong Kong recently. Generally, I think it's an area where legal can be very useful to the business and useful to ER in terms of keeping education going. And then discrimination. Did you have a question? No? Discrimination. I know I'm rattling through what might sound like a sort of one-to-one on employment law, but these are the sort of things we get asked about. Discrimination is really important. Hong Kong's a bit of an outlier in that it has developed a very decent body of meaningful anti-discrimination laws, and it's had those in place for 25 years. So it's different from most Asia jurisdictions, excluding, of course, in APAC, Australia and New Zealand, which also have very developed, mature anti-discrimination laws. Hong Kong does have a body which most of you probably know this, but just to recap, there's about 7 different things which are protected, including race, gender, pregnancy, sickness, and family status, marital status, and recently breastfeeding. So it's very, very important indeed that these laws are taken into account and that everybody understands them, not just the people in HR and ER, but the businesses, everybody. In fact, it's extremely good practice. It's not quite a legal requirement, but it's very, very strongly recommended that education and training is given regularly, annually, to people who in your organization. We give this sort of training. The EOC gives this sort of training. I'm sure you do something in-house. It's a legal requirement in certain jurisdictions, such as New York. Not a legal requirement here, but very strongly recommended. And why? Because you don't want to be the first bank or the first TMT company or the first company in Hong Kong, which is going to be on the front page as having been stuck with a judgment against you for sexual harassment or pregnancy discrimination or disability discrimination or something like that. Quite apart from the legal exposure, there's a huge stigma and reputational risk attached. So again, I think that's an area where it's really, really important that everybody talks to each other. And then I'll stop in a minute, but...
Thank you, Fiona. I think you've sort of gave us like a Employment Law 101 for Hong Kong, and then from corporate perspective about the reputational risk that may be involved in the HR issues. I think another sort of quite frequently asked questions will be about termination and dismissal, which can be quite tricky as well. If not handled properly, can also be a reputational issue for the corporate. And there are so many reasons that from the business perspective, management perspective, that they will like to dismiss someone, terminate someone, fire someone. But then there must be a legal ground. It's not because, oh, I don't like this person or because the performance is not great. There should be like a process, legal grounds to do so, right? And sometimes mutual separation can be considered as well. So any advice on that, Fiona?
Well, I would challenge you slightly there because this is a gathering of Hong Kong lawyers. And it's still legally the case in Hong Kong that you don't need a reason to dismiss. What you do need to do is make sure that none of the prohibitions and restrictions apply. And you also need to make sure that there is no ground for dismissal in play, which could be said to be discriminatory. But provided the person is not on maternity leave or hasn't given notice of intention to take maternity leave, provided they're not on sick leave, provided they haven't had an accident at work, and provided there's no nexus with a discriminatory ground, for example, dismissing somebody because they're taking time off too often to go on maternity leave, or something like that, then you are generally okay to dismiss somebody as long as you pay them the requisite amounts. Now, of course, there will be occasions where summary dismissal is justified, and that forms an exception to the prohibition on dismissing somebody who's on sick leave or on maternity leave. But leaving aside cases of summary dismissal, which, as many of you will know, can be really hard to justify in the courts in Hong Kong and similarly to elsewhere. Leaving those aside, generally, as long as you take care not to fall into the traps that I've mentioned, you will be able to get rid of somebody. Now, of course, the organization may choose to go through a process, right? That's very common. And I'm not saying that you shouldn't do that, but just we're here to talk about law rather than good practice. If an organization has chosen to give a commitment to its employees that they will not dismiss without going through a grievance procedure or a disciplinary procedure or something like that, then that kicks in. And of course, that must be taken into account. But the legal position is that Hong Kong is still a pretty employer-friendly place in which to operate. I can see somebody in the audience really frowning as if they disagree with me, but feel free to send a question or make a comment if you wish. I think you also wanted me to say something about separation agreements.
Yes, mutual separations. When should it be considered and negotiated?
Yeah, I mean, this ties in with what I was just saying. Hong Kong continues to be an employer-friendly place to be. And I'm not sure that it's always wise to adopt the approach that you must have a separation agreement. But a lot of the American clients we work with, American-based clients, take the different approach, and they will always have a separation agreement. But you need to proceed with some care. You don't want the employee, and I hope I'm coming across as employer-friendly, but I am employer-friendly. I act for corporates, not individuals. And so I often caution the corporate clients, don't make the guy think, or the person think, that he or she has got legal rights. Hong Kong is Hong Kong. This person may not understand that, particularly if they've come from a different jurisdiction, but provided there's no discrimination, and provided none of the employment ordinance restrictions that I mentioned apply, then you can separate. Now, of course, many of you in this room will act for clients or work within clients where there is a practice of paying people, severance when they go. And of course, that is a good thing. An amicable separation is a good thing to achieve. People come back. You've got reputations to think about in the market. And of course, if you're giving somebody something extra over and above the legal entitlements in Hong Kong, then there should, of course, be a separation agreement, just for peace of mind, to know that the line has been ruled underneath. And it should include all the good things about non-disparagement and confidentiality and reaffirmation of restrictive covenants and so on. Another example of how HR or ER could benefit from involving legal is that I think only the lawyers sometimes understand the value of getting the restrictive covenants reaffirmed at the time of separation. It's much easier to enforce restrictive covenants that are given in the context of a departure and a separation agreement than those that are given when a person joins. So that's something to think about as well.
Any other points that we should note when we are negotiating the mutual separation agreements? Anything like privilege, anything like that we need to take care of?
Yeah, I mean, privilege is something that I think is sort of obvious. There will be times when you want discussions to be privileged. You want the discussions both internally and with the individual. And that is, again, another reason for involving legal. I don't think we need to go over with this group how you create privilege, but just remind that it can be easy to lose privilege by a careless communication being exchanged, maybe between the business, discussing something and making a comment which could be discoverable in the future or have to be provided pursuant to a data access request.
Yeah, I think Fiona's sharing is very, very helpful and useful, because I think not all of us in our corporates, we have the luxury to have Michelle as a dedicated employment lawyer, but we have like the words of advice from Fiona today on some points to note, some guidance, some pointers here in terms of handling some tricky HR issues in the corporate. And then turning to Michelle, we talked about like personal data in the first session, and I think personal data is also one of the very important part in HR and perhaps even in dismissal, termination, etc. So any views on the handling of personal data in such circumstances?
Yeah, so one point Fiona mentioned just now was data access requests. So these I have seen used quite a bit in contentious termination. So where you have an unhappy separation, data access requests can be used by the individual as a tool to almost do some pre-litigation discovery. Technically, it's not supposed to be used in that way. The guidance provided by the Privacy Commissioner says it is not to be used for phishing purposes. Unfortunately, if you suspect that it is being used for phishing purposes, that is not a ground to refuse to comply with a data access request. So, and this is where communication between HR and legal is incredibly important. Data access requests have to be complied with within 40 calendar days, not working days, calendar days, so just over a month. And in some organizations, you may have a dedicated privacy team. If not, then legal have to handle it. And it's very important that HR and legal, or the privacy team, all work together to gather all that information. Depending on the organization size, record keeping, this may actually take quite a bit of time. It also depends what the individual is looking for. Often we'll see a request for employment contracts, correspondence, termination letters, pay slips, appraisals, notes around decisions to terminate, notes around bonus payments, anything like that. And they do it under the guise of personal data. And often they're gathering information, and this is not always the case, but often they're gathering information to bring a claim in the Labor Tribunal, the EOC, various other places. So it's very important that you stay on top of that. And that's where communication really is key. And also from a legal perspective, it's also very important that as part of that exercise, that the organization has complied with the PDPO as well. So in terms of guidance, the DPPs, data protection principles, all of the collection, storage, use, all of that. Because if someone asks for information and the organization is supposed to have it but doesn't have it, that could also be a problem.
Thank you, Michelle. Perhaps I can also throw the next question to you, Michelle. Any suggestions to improve collaboration between legal and HR and to maximize the resources? You talked about communication, but how can we improve that on a daily basis?
Yeah, so I think really the key point is communication, delineating tasks, making clear what is HR's remit, what is legal's remit. And I think from an HR perspective, making very clear what they run with, and then making very clear what legal run with. So from an HR and ER perspective, for example, they will often have the skill set to deal with employees directly. For example, in my role, I don't necessarily deal directly with employees. For example, day-to-day redundancies, I don't personally carry them out. That would be for HR. So that's their skill set. And also for internal investigations, often HR and ER may be better placed to run them. They're more aware of the actual process that they have to go through. There are various hoops that need to be jumped through to follow your own investigation process. And they will have the information at their fingertips. They can access the employee personal data, the P files, contracts, all of that, that you may require. And also company policies, adhering to contractual documentation, that should all be within HR's remit. And HR should also be the owner of HR documentation. Legal can review and help update, but really it should sit with HR. Obviously, it will depend on how the organization is set up, but I think the best way to maximize resources where you may have a very lean team, both in legal and in HR, is to make it very clear who is doing what. And then that also goes back to the question of risk and how to minimize risk and make sure nothing falls through the cracks. Because something comes in and HR know they run with it. And if they need legal input, they come to us. Something else comes in, like from the Labor Tribunal, that lands on my desk and I handle that, not HR, for example. Fiona, what about from a legal perspective? What would you say the legal team would be in charge of?
Well, I completely agree that clear demarcation of responsibilities is absolutely essential. And even within the HR team, the ER team, and legal teams, obviously, working out and identifying and putting on record who's responsible is very, very useful. I agree with what you've said in your broad discussion of what the difference in responsibilities would be, broadly speaking. I do think it's good to have somebody in the legal team who's responsible for giving regular legal updates to HR and payroll. I mean, I mentioned earlier the formula for calculation of payment in lieu of notice changed, but in fact that change to formula impacted on all statutory payments. And you would be quite surprised that a number of employers took some years to play catch up with that change, which resulted in a problem for some of them because they had to make back payments over a few years and so on, and explain the disparity to the Labour Department and to their employees. So I think just somebody taking responsibility for looking what has happened in the last quarter. Is it something that I need to get a little roundtable discussion going on? I think that's a good idea.
Have you come across situations where the HR team, they have changed, like new persons joining the HR team, and then they're asking the same questions all over again? Any way you think it will improve that situation? How to tackle that?
So I'm going to go back to this point about communication. So it's not just communication with legal and HR, but communication within HR themselves. One thing that when I joined the bank, I worked very hard with HR to get them to talk to each other. HR professionals often have a wealth of experience, whether within the bank or your organization or their prior organizations. And so if they talk to each other, they may find that someone else has had the same situation, or that someone has come up with a very creative solution to the same problem. So in my first 2 months, I was getting the same question every week from different people, and getting them to talk to each other and create their own knowledge bank really helped. It's especially true where you have a large organization and lots of HR people. Just reminding them that they are their own knowledge bank can be very helpful. But I'm sure, Fiona, you get the same, clients calling you about the same thing all the time.
They do, and we have to remember. I hope you can hear me. I think there's some problem with one of the mics. Yeah, we do. And we have to be very careful. We don't want to charge a client. We're not going to charge a client for advising them on the same thing twice. So we have to, remember what we've advised on before. We have to monitor it. We have to keep records, obviously. We have to make sure we advise in the same way. We've got quite a big team, and some questions are really easy to answer. There's a black and white answer, and sometimes there are nuances. And, that's part of why I like employment law. I didn't start off life as an employment lawyer, but I like the nuances. I like the interpretation. But we have good communication within our own team, and we often talk about these gray areas. And sometimes we will even acknowledge to the client, Sarah thinks this, I think this. The court could go either way. So, yeah.
Thank you, Fiona and Michelle. Michelle actually mentioned something about incident handling, and usually there's a process, the HR should be running the process, but then it usually happens in a very high pressure environment. And as I mentioned in my introduction, legal may be brought in at quite a late stage. And often in the internal units, for example, senior management, legal, HR, they may take different views on things and may have different risk appetites. So in handling this kind of situation, what's your view as to where legal should stand, whether we should take the lead or in terms of decision making? The process should be run by HR. You mentioned about that, but how about the decision making?
So I think it's very important for legal to be involved in the decision making. Both to provide legal advice, but to assess the risk. But I think the ultimate decision will often rest with business. It really depends on what the issue is, but it will more often than not involve a sum of money and or, for example, the termination of an individual's employment. And it is for the business to decide whether they are happy to pay that sum of money or to forego that resource if they are going to terminate an individual. So I think legal's role in that is to provide support, but to make very clear what the legal position is, but then what your options are. So looking at the end goal, if the end goal is to terminate an individual, it's almost like working backwards. You say, okay, we can terminate under the law, as Fiona said, relatively easy to terminate. Check there are no discriminatory issues, they're not pregnant, on sick leave, etc. And then work backwards from there to see how best to execute to get the business to where they want to be, but also respecting the risk appetite. If they need to pay a sum of money, how much their ceiling may be. If they ultimately want to keep the person, how you navigate that.
Fiona, any experience sharing here? I think you're getting a lot of this kind of...
no, it's great. We're singing the same song, Michelle and I. Unsurprisingly. Just one thing to add, both of us have stressed to you that Hong Kong is an employer-friendly jurisdiction. Both of us know that. and that's good for our client, our corporate clients. But you do need to make sure that there's no nexus with a different, less sympathetic to employers' jurisdiction, right? And I think that the last year or so has seen a big increase in the risk of a different law applying simply because of the practice of remote working. You know, we all know people who took off from Hong Kong some time ago for a short trip and didn't come back, or just have kept something open-ended. And some of those people have now been working in those jurisdictions long enough for tax consequences, personal tax consequences to be triggered, corporate tax consequences to be triggered. That's another risk, another topic. But most of all, if somebody stays long enough in a jurisdiction where your client, particularly if it's a jurisdiction where your client has a presence, then there could be, depending on the detail of the arrangements, substance to the argument that that person has acquired protection under, for example, English law, a right to claim unfair dismissal, which doesn't exist in Hong Kong. Australia is another place that has a lot of protective laws. Korea, Japan, Germany, France, all these places. So that's something I would add.
Thank you, Fiona and Michelle. You just talked about COVID, so perhaps let's turn to the COVID situation. So it's been going on for 2 years, and many corporates has adopted different policies. Some of them has adopted return back into the office, and some of them they have chosen to adopt a hybrid mode, so the employee may choose to come back into the office or work from home. But then here it comes the issue from HR perspective, whether from corporate as an employer can force the employee to just do one way or the other. Oh, you must come back into the office, even if the nature of work of that employee permits to work from home, but whether the corporate is entitled to force the employee to do one way or the other. Then when it comes into the policy making of this type of things, it's not just about the legal requirements. There are also the employee sentiments. Oh, I want to work from home. I prefer to work from home. So how do you balance that kind of like different interests and the legal requirements? What's your view? Fiona, Michelle? Fiona?
I'll start and then you can add. A huge question, and it's definitely on the list of frequently asked questions these days, although that will not continue forever. Do employers have a legal right to demand people to come back? They probably do, because the terms and conditions of employment will probably say your place of work is our office, our Hong Kong office, or wherever the office is. And although that has been varied for the life of the pandemic and restrictions still in place in Hong Kong, much less so elsewhere, although that has been varied, I'm pretty optimistic. I'm pretty sure that the courts will take the position that that was not a permanent variation. That was by nature of a temporary concession, which was required by the circumstances. Yeah. So that's my view on that particular question. In terms of balancing, that's very difficult indeed. There are lots of things to take into account, and one of them is retention. There is a war for talent. There are jobs which employers are finding it very difficult to fill. You may want, let's say the employer's policy is, or preference at this stage, is that most people are back in the office, or they're back in the office for 4 days a week, or something like that. But there's a key team, a really important team, and they like working from home. A lot of people do like working from home. A lot of people don't like working from home. It varies company to company and place to place. I mean, I think if I lived in the UK, I would probably be much more keen on working from home because I'd probably have a commute. Here, I'd much rather be in the office. So a lot of things to balance.
Yeah, I agree completely, Fiona. It's dealing with the second half first. The employee sentiment is very hard to gauge because everybody wants something different. And so it's also finding a balance with what works for the organization. I completely agree with Fiona's comments that the starting position is everyone is back in the office because your contract says so. And that the COVID variation was not a permanent variation, it was due to circumstance. But obviously the argument then comes back of, well, I've been working from home for the last 2 years. Why can't I continue to do so now? And so finding that balance, because if you have everybody working from home, you lose that community spirit and community feel in the office. What happens to Friday night drinks? You know, there's one person and a bottle of wine. But you also have to recognize that people want that flexibility. So it's a very hard balance to reach. And I think as an organization, you need to get a feel for your employees. So do a survey, ask around, speak to people, but then also work out what works for you as an organization. There are going to be some roles that you just can't do from home. There are going to be some roles that you could do 100% from home, but you have to put in some consistency. And you're never going to have everybody 100% happy. Someone's always going to complain about something. So you do the best that you can, and ultimately what works best for the organization.
Yeah, I think, thank you, Fiona and Michelle. This is a big topic that we've been thinking about. I think many corporates have been also thinking about the best approach for themselves. And I think there's no easy solution, but just number one, of course, the legal requirements, and number two, just understand and communicate, not just with the HR department, but with also your employees, just to understand more what they want and more communications there. Another hot topic about technology. So I think there are lots of use of technology nowadays in the HR process, recruitment, hiring, etc. So there is a standardization on processes, which is a good thing, right? Making things more efficient. But then does it help with the alignment between HR and legal? Or do you think with everything now online, legal is being left in the dark even more? What do you think? Maybe Michelle is an in-house.
That's a good question. I don't think legal's being pushed out or behind, as it were. But I think if the organization is going to implement online processes or, automatic processes, legal should be involved, because it means that, for example, you have someone fill in an online application or do an online questionnaire. Legal should go through those questions, make sure there's nothing discriminatory. We're not asking people, do you plan to get pregnant in the next 6 months? And various other things. So we can build in some protections. And so I think legal plays a very important part in that. And automating the process, I think overall will be a good thing. It's more efficient, time efficient, resource efficient. But I don't think that means that, legal takes a back seat.
Perhaps one last question from me before we open up for the Q&A from the audience. So I can pick up the common sort of traps that you both mentioned is about discrimination. So anything that you can share more with us? What from an in-house lawyer perspective we need to take care of when the HR comes to us on certain occasions, for example, like the questions that we briefly touch on, whether we can dismiss someone where he or she is on sick leave, a long-term sick leave, and then all the statutory leave has already been utilized, then whether we can dismiss that person because there may still be a discrimination issue, anything like that you can share in your experience. Some free advice here, Fiona?
Sure. Shall I go? Yeah. Yes, you should all treat these types of seminars as an opportunity to get free legal advice. Yeah. This is unfortunately quite a common scenario, a reasonably common scenario in the sort of things that we get asked about. Joyce has described the situation where somebody is on sick leave, they use up the statutory sick leave, can you then dismiss them? So the way I always describe it to overseas clients who might not be familiar with the Hong Kong law is there's the first level, the absolute prohibition in the employment ordinance. You cannot dismiss somebody as long as they are entitled to statutory sick leave. Statutory sick leave is really generous in Hong Kong. It's surprising. In New Zealand, I think you get, last time I checked, I was comparing this with somebody at a conference, I think you get 2 weeks of paid sick leave. Here, you accumulate 2 days of sick leave per month during the first year of service, and 4 days thereafter, up to a rolling maximum of 120 days. And that's probably 120 working days, not calendar days, depending on how you administer your payroll. So once you get to the end of that statutory sick leave, if the person comes back to work, then he or she can then dip into the days that have accumulated during the statutory sick leave. They continue to accumulate. But if they don't come back, or sooner or later the days run out, what then? It's very difficult, because if you do get rid of somebody in those circumstances, there's almost an inference that it's because the person is on sick leave. And if the disability, the sickness, known as disability for the purposes of the Disability Discrimination Ordinance, is even one small part of the reason for selection, then you're guilty of discrimination, the manager who makes the choice or the employer. So it's something where you have to proceed with great care. If you're making a whole team redundant, including that person, that would be different. But if you're not, then it's not an easy situation to resolve.
Yeah, completely agreed. And I think one other point to bear in mind is the reputation risk. You have an individual who has been on long-term sick leave, which normally means they're very sick, and then to terminate them, albeit while they're not on statutory sick leave, but probably still quite ill, is not a great look.
Perhaps I can follow up with a small point here. So whether from an employer perspective, as an employer, we are entitled to access the medical records of the employee in such situation? I think there are some personal data issues involved here.
Yeah, only if the employee agrees, has to give their consent. And I would make it very clear when you seek that consent that you're only going to use the information for the purposes of whatever you're going to use it for, assessing whether they can require accommodation, for example.
Thank you. So let me open up for the audience for Q&A. Any questions from the physical audience here in the venue? Or maybe we can answer the questions from the online Q&A. So it's about restrictive covenants, whether we can impose, as an employer, impose restrictive covenants during the course of employment or at the point of termination, or whether all restrictive covenants must be renegotiated prior to the signing of employment contracts.
Easy question to answer. Yeah, hope you agree. Be fun if you didn't. You can impose restrictive covenants at any time, but you must make sure that there is consideration for them. And that's why usually they're included in the original offer. Some clients will renegotiate them and reimpose them and get an affirmation. Remember, I mentioned affirmations earlier on in the context of separation agreements. Some clients will get people to reconfirm to them when they're promoted or periodically as a condition of receiving a bonus. And why would you want to do that if you already have them in place? The reason is that the reasonableness of the restrictive covenant is assessed at the time of at which it's given, not years later when somebody departs. So somebody could be hired as a 2-year out salesperson, very junior. They're asked to enter into restrictive covenants. For a 2-year out junior salesperson, a 6-month or 12-month non-compete is not reasonable, but the person does really well, becomes very senior. If he or she has been asked to re-give the restrictive covenants the previous year when they were promoted, then you will have a much better chance of getting enforcement.
Yeah, completely agreed. And because you need to, restrictive covenants should be tailored to the role, to the person. So very much to Fiona's example, you could have a very senior individual who has a restrictive covenant from when they first joined, and it wouldn't be appropriate. So very much agreed.
And definitely put them in a separation agreement. I mentioned that earlier because it'll hugely increase your chance of enforceability.
Thank you. And there is one more question from the Zoom Q&A. Are termination service useful after termination? Any insights, any experience?
That's a good question. I guess it depends how honest people are feeling, because they're only useful if someone is actually honest. But if someone doesn't want to give you feedback or is scared to give you feedback, and this is where non-retaliation policies come in, non-victimization, et cetera, then you're not going to get any useful information. So I think you can try, and I think most organizations will do some kind of exit interview or termination survey, but as to their usefulness, it depends the data that you get.
I'm being mindful about time. I can see that questions still coming in, but I'm being mindful about time and your lunchtime. So I would like to call it an end to this session, and thank you one more time to Fiona and Michelle for your very insightful and honest sharing. Please give a big round of applause to Fiona and Michelle. Thank you.
Thank you all. Would our panelists please stay, as we would like to present your souvenir. May we invite our Vice President, Mr. Roden Tong, to come onto the stage and present the souvenirs for us. Roden, please. Let's take a group picture. Thank you. That's all for the morning section, and we will return at 2 p.m. after the lunch break. If you're not joining us in the afternoon, thank you for coming, and I shall see most of you again at 2 p.m. Thanks.